Greetings and welcome to our program, A Threat to Judges and Judicial Independence. I'm John Frungen, Director of the William J. Hughes Center for Public Policy at Stockton University. We are pleased to partner with the Hispanic Bar Association of New Jersey to bring you today's forum on judge safety and judicial security. The mission of the Hughes Center is to promote civility in government and politics and to inform the public about important policy issues. The increasing number of threats against judges jeopardizes our democracy. This program will outline the problem, report on trends, and discuss best practices in judicial security. To learn more about the Hughes Center for Public Policy or to support this kind of work, please visit us at www.stockton.edu/Hughes Center. We will now hear from Albertina Webb, President of the Hispanic Bar Association and a partner at Hill Wallach LLP, as she introduces our keynote speaker. Abby?
Good afternoon, John. We thank you on behalf of the Hispanic Bar Association for inviting us. My name is Abby Webb. I am a partner at the law firm called Hill Wallach, and I am the president of the Hispanic Bar Association of New Jersey. It is my privilege to introduce our keynote speaker to participate on this online forum on court security and judicial safety, Judge Esther Salas. In 2011, President Obama nominated Judge Salas for elevation to the United States District Court. At the time of her elevation, Judge Salas was the first woman to assume that position in the District of New Jersey. Prior to becoming a district court judge, Judge Salas served as a United States magistrate for the district from 2006 to 2011. Judge Salas was the first Hispanic, male or female, to serve as a magistrate judge in that district. In the interest of time, I will not be reading her bio, but I did want to take a moment to say that at the Hispanic Bar Association of New Jersey, we are very proud to call Judge Salas a member of our familia. In addition to serving as a past president of our association, she has remained a staunch supporter of our association, our goals, and its endeavors. As many of you know, on July 19th, 2020, a disgruntled lawyer with hate in his heart appeared at the door of her home, rang the bell, and took the life of her only son, Daniel. The murderer then attempted to kill her husband, Mark.
Well, I think we're having some technical difficulties, and so I am going to take it over from this point. And I do want to thank Stockton University, William J. Hughes Center for Public Policy, Hispanic Bar Association of New Jersey, and its president, Abby Webb, for the opportunity to speak to you all during this groundbreaking forum on judicial security. Since my son's tragic death, and considering what I've learned as a person trying to heal from the unthinkable tragedy that we experienced, gratitude has become a necessary component to my healing process. And so in the spirit of gratitude, I want to just take this opportunity to thank all congressional leaders who sponsored and or supported the Daniel Anderl Judicial Security and Privacy Act. At the risk of leaving any association out, any organization out, or anyone at all, because that would simply kill me, I'm just going to generally thank all the associations, all the organizations, and every single person that helped to get the federal bill passed. I would be remiss if I didn't take this opportunity to publicly thank President Biden for signing the act into law on December 23rd, 2022. And as a proud New Jersey resident, I can't pass up on this opportunity to thank all of the New Jersey legislators and Governor Murphy for the quick passage of the New Jersey law, which is also named after our son. New Jersey's swift passage of Daniel's law and the steps taken since its enactment in November of 2020, I might add, just 4.5 months after our attack, New Jersey now, because of that, has undoubtedly become a national leader when it comes to judicial security. The protection of the judiciary and ultimately of our democracy needs to be made a priority by every state that has yet to enact legislation to protect its judiciary. Judges at every level of government need to be protected. Sadly, there are far too many examples to point out when we speak of the constant and repeated attacks on the judiciary, the rule of law, and ultimately democracy. Since 1979, we have watched in horror as judges have lost their lives or the lives of their loved ones, all because they were doing one thing, their jobs. I want to take a moment to remind us of some of these tragedies. We start with Judge John H. Wood Jr. Judge Wood was assassinated by a sniper in the driveway of his San Antonio, Texas home on May 29th, 1979. I read when I was researching this that he was standing at the door of his automobile when the sniper, a convicted hitman, callously took his life. Richard J. Duranko was killed on May 19, 1988 by the father of a disgruntled litigant. The judge was at home, in his home in Pelham, New York, gardening outside, when this man approached him with a gun. The judge saw the man, began to run to his backyard, and the man began to shoot the judge. The judge ran into his home, and the attacker followed him, continuing to shoot the judge. Inside the home, the judge's wife, his daughter, and her boyfriend at the time saw this whole thing unfold. Ultimately, the attacker killed himself within feet of dead Judge Duranko. On December 16, 1989, Judge Robert Smith Vance opened a small brown parcel in the kitchen of a suburban home. It was Christmas time, December 16th, and he lived in Mountain Brook, Alabama. Unbeknownst to Judge Vance, the package contained a mail bomb, which instantly killed him and severely injured his wife, Helen. An investigation revealed that Judge Vance's killer was angry with the U.S. Court of Appeals for the 11th Circuit, which had refused to expunge the killer's prior conviction. The irony of this one is that Judge Vance wasn't even a member of the panel that considered the killer's case. And in the early morning hours of February 28, 2005, an angry litigant, upset with Judge Lefkow, her ruling in his case, he snuck into her Chicago home with a plan to assassinate her. There was a suicide note left behind, so much of the information that was gathered from that note. And we know that the killer waited for hours in a utility room in the basement of the judge's home. Tragically, when the judge's husband, Michael, came across the killer, he killed him and then turned the gun on her elderly mother, who had heard the commotion and called down to her son-in-law. When Judge Lefkow returned home that evening, she found her loved ones' lifeless bodies on the basement floor. It is said upon reading the killer's suicide note, Judge Lefkow's worst fear was confirmed. Her job cost her the life or the lives of her husband and mother. And on July 19, 2020, my only child, Daniel, was murdered in the foyer of our home by a self-proclaimed anti-feminist lawyer who I believe was also a racist. I'm not sure what he hated more about me, that I'm a woman or Hispanic, or that I had the audacity to be both and become a judge. No matter the reason, his plan to assassinate me led to the senseless murder of my 20-year-old son and almost cost us the life of my husband, Mark. We've been married now for 28 years. Although much has been reported about what happened right before the shooting, I want to spend my time today talking about what occurred days before the murder of our son, Daniel. Based on 2 FBI debriefings, Mark and I learned that on July 4th, 2020, the killer boarded a train from the Northeast Corridor headed toward his ultimate destination of San Bernardino, California. We learned that on July 11, 2020, just 2 days before Daniel's actual birthday, the murderer posed as a delivery man, walked up to the front door of the home of a California lawyer, one he was angry with, rang the bell, and insisted that the lawyer come to receive the package. When the lawyer came to the door, Daniel's eventual killer shot the lawyer multiple times and even stepped into the foyer to finish the job. Immediately thereafter, Daniel's killer left the scene and made his way back to the East Coast. And on July 16, 2020, Daniel's killer checked into a local hotel less than a mile from our home in North Brunswick, New Jersey. We know through cell phone records that the killer was on our block Friday, July 17, as Daniel's friends came up to our home. They were coming to celebrate Daniel's birthday. He was watching. He was watching. And the next day, Saturday, July 18, as Daniel and his friends were eating the breakfast that I prepared for them, I wanted to give Daniel privacy. So I took our 2 dogs and decided to walk down the block to a grassy area at the end of the block. And as I was walking, I noticed that there was a car that seemed out of place. And so I turned to look at the driver. The driver turned to look at me, and our eyes locked for a moment. I would later discover that that was the man that would take the life of my only child. He watched that day as I packed Daniel's car with beach chairs and an umbrella and a cooler. He watched our every move. And finally, on Sunday, July 19 at 5 p.m. in the afternoon, he calmly walked to our door, rang our bell, and within seconds, took the life of our beautiful boy and tried to take my husband's life as well. We learned that before coming to our house that Sunday afternoon, the killer had extended his stay at the hotel for 3 more days. And when I asked the FBI agent during one of our debriefings, why do you think he did that? The agent just looked at me and he said, ma'am, he was going to kill you. And he was going to stay long enough to get it done. I remember asking the agents, but if I'm the person that he wanted, why? Why didn't he come in? He must have at that point heard me screaming as I was running up the stairs from our basement. And the special agent in charge looked at me, and I'll never forget what that agent said. Without skipping a beat, the agent said, well, ma'am, he was met by superior forces, your son and your husband. Little is known about the brief exchange between Daniel and the killer. But what we do know is that Daniel wasn't going to let that man step a foot in our house. Daniel fell back with his arms out like this in a cross position. And we believe it indicates that he attempted to block the killer's entrance into our home. The forensic investigation confirmed our beliefs. It proved that there wasn't one footprint of that man in our foyer. No, Daniel and Mark made sure of that. And on his part, Mark kept taking bullets, one right after another, as he tried to get the shooter. Mark sustained 3 shots that hit 5 different parts of his body. It is a miracle that my husband survived the brutal attack. And in the days, weeks, and months following our son's murder, we learned so much about his killer. We learned of the dossier that contained so much of my personal information. He knew my routes to work, the schools Daniel attended, had a list of Daniel's baseball games, information about Mark and where he worked, and even knew what parish we belonged to. We also learned of a list of names of other potential witnesses. Strike that, of other potential victims. And although I've never bothered to read his manifesto, and I will never bother to read his manifesto, I, like Judge Lefkow, had to come face to face with the reality that my job cost me the life of my only child. As Mark and I continue to struggle, as we were continuing to struggle with his life-threatening injuries, we learned more and more details about Daniel's killer. The investigation had uncovered a storage locker belonging to the killer. And inside that storage locker, they found another weapon and a manila folder. And inside that folder was information on Justice Sonia Sotomayor. And just as he had done with me, he was beginning to compile information on the justice. He knew her favorite restaurants, where she worked out, and even had copies of visitor guides for the Supreme Court. All of the information in my dossier and in Justice Sotomayor's file is classified as by the FBI as open source information. And despite the passage of the federal law, much of this open source information remains readily available on the internet. Let me take a moment to explain what the Daniel Anderl Judicial Security and Privacy Law does and what it doesn't do. This narrowly tailored law limits the availability of federal judges' personally identifiable information, what's called PII. It limits, again, it limits the availability of the PII in federal databases and restricts data aggregators from reselling that information. Although the law allows judges to redact their PII, it excludes such redactions when there are legitimate media interest in the information or it involves a matter of public concern. The law does not restrict speech. It merely provides federal judges an opportunity to protect themselves by ensuring that their home addresses and other confidential information is not readily accessible to those wishing to do us harm. The law has also created a vulnerability management program within the Administrative Office of the U.S. Courts. Through this program, the AO can monitor and react to internet threats and provides enhanced training for judges. The law provides redress, injunctive and declaratory relief, and penalties, fines, damages, court costs, attorney's fees to enforce provisions of the Act. It strengthens the capability of the U.S. Marshal Services, which is critical here. The U.S. Marshals, by strengthening the capabilities of the U.S. Marshals, they can look at threat intelligence and analysis, and in order to anticipate and deter threats to federal judges. And when you combine the vulnerability management program and the strengthened capabilities of the U.S. Marshals, federal judges will be better protected because this law was passed. That is undeniable. However, there are the federal law has limits. The federal law addresses the threats that federal judges face. As far as the removal of PII, for federal judges that are sitting in states that currently have no laws like New Jersey's law, the removal of their PII is temporary, since most of the personal information will be repopulated by the particular state agency websites. Even when services like Delete Me can take down our PII, that information is quickly repopulated by state-run agencies. Most of this personal information is readily accessible through tax records, motor vehicle records, and voter registration lists. So how do we protect other judges that are not directly impacted by the federal law? Well, the Andor law authorizes a state grant program which incentivizes states to establish or expand programs to protect and prevent disclosure of all judges' PII. I'm emphasizing the word all. State judges face the same threats that federal judges do, and violence against the court also threatens state court systems. I'm very grateful and extremely pleased by the example New Jersey has set. And later in our program, each of you are going to hear what a remarkable job New Jersey is doing to ensure that its judiciary is safe. But New Jersey's law also protects prosecutors and law enforcement officers. It's very expansive and comprehensive. However, we need to work together to ensure that all judges across this great nation are safe. And we can't just sit idly by and wait for another tragedy to strike. I'm here to urge other states to follow New Jersey and to enact similar laws that will help save the lives of judicial officers, their families, and personnel. To my knowledge, at the state level, there is currently no way to track the number of inappropriate communications received by state judicial officers. Now, federally, there has been an alarming rise, and we know just how drastic the rise has been. Because that information is monitored, tracked, and logged by U.S. Marshals, we know that in 2015, they had 926 inappropriate communications lodged at judicial officers. In 2020, strike that, in 2021, actually, that number skyrocketed to 4,511. However, currently, there's no way for me to tell you what the numbers look like at a state level. Because again, to my knowledge, there is no centralized repository that is tracking the number of inappropriate communications against state and local judges. We don't know which judges, how many have been killed because of they were doing their jobs. The information, as I understand it, isn't being monitored by one central source. Listen, much remains to be done to protect judges at all levels of government. As I said earlier in my remarks, we need to make protecting our democracy a priority in this country. And it starts by ensuring that all judges are free to do their jobs without fear of reprisal, retribution, or death. After the brutal attack on my family in July of 2020, nearly 2 years later, in June of 2022, an armed man was arrested outside the home of Justice Kavanaugh. And it is alleged that he intended on killing the justice. Where do you think he found the justice's home address? You guessed it, the killer found the justice's home address on the internet. Within days of this near miss, the country woke up to another tragedy. But this time it involved a retired Wisconsin judge. Judge Romer was assassinated in his home by a man he had sentenced 15 years earlier. A magistrate judge in Florida required 24-hour protection for a ruling that he made on a search warrant for former President Trump's Mar-a-Lago home in Palm Beach, Florida. And just a few days ago, a New York judge presiding over a case involving the former president has now received numerous threats requiring increased security. Ladies and gentlemen, the rise in these alarming threats against judicial officers all throughout this country mandates that we band together to ensure that all judges are protected. There's too much at stake. It's too much at stake for us to do nothing. As Mark and I do our best to pick up the pieces of our shattered lives, I'm here to tell you that there are no words that I can use at this moment to describe what the last 2 years, 8 months, and 24 days has been like for us. There's nothing that can be done for Mark. There's nothing that can be done for me. Our lives are forever changed as we're forced to live the rest of our lives on this earth without our Daniel. However, there are things that we can do together to protect all judges and ultimately our democracy. The Daniel Anderl Judicial Security and Privacy Law, it's a solid step in the right direction. It is. But we can't stop there. We must now take the necessary steps to try to incentivize other states to follow New Jersey and the handful of other states that have enacted laws that are aimed at protecting the judiciary. Now, there is some information that we pulled, and we pulled it from the Library of the U.S. Courts of the Seventh Circuit. It's a survey on state statutes on person and public officials. And the information seems to suggest that there are approximately, as of February 15, 2023, it appears there are around 30 states, including New Jersey, that have enacted laws that either specifically protect judicial information or have protection laws that include members of the judiciary, but are not specifically aimed at judicial officers. It appears that around 7 states, including New Jersey, have enacted specifically laws to protect the judiciary. And it appears that 6 states have proposed judicial specific protection laws similar to Daniel's law. Ladies and gentlemen, if we don't do something, if we don't band together to encourage our sister states to pass similar laws, I fear for this country. In history, violence against the judiciary has been closely tied to the toppling of democracies all throughout the world. Autocrats deliberately set out to discredit and delegitimize independent courts that serve as safeguards of constitutional democracy and the rule of law. We saw this in Nazi Germany, where Jewish judges were removed ahead of the entire reshaping of the German judicial system. Same playbook was utilized in Turkey, when huge portions of the judiciary were replaced by loyalists, or were replaced with loyalists. And in Venezuela, where a judge was jailed for ruling outside that leader's outcome, what he wanted, his desired outcome. In Hungary, where the entire judicial system was reshaped to suit that leader's agenda. And it continues to date. All you need to do is follow the news. When you want to topple a democracy, you go after the judges. And you go after the judges first and foremost. In our country, our constitutional system hinges on an independent judiciary. We must be able to do our jobs without being afraid for our lives or the lives of our loved ones. Fear is at the root of all evil. Fear will weaken the constitutional fiber that has made this country so strong since its inception. Judges stand on the front line protecting democracy and the rule of law. The integrity of the judicial system mandates that we stand united to protect our country's democracy. We cannot sit back and allow these anti-democratic efforts to go unchallenged. We need to send a message. We need to send a message to all those wishing to harm judges or jeopardize the rule of law. And that message is that in the United States of America, we do not tolerate these kind of acts of coercion, threats, and intimidation. We don't tolerate it here in America. We in the judiciary know that the time is now to urge our sister courts to pass legislation that can better protect judicial officers all throughout this country. It isn't going to be easy. I know that. It isn't going to be easy to get 40 plus states to enact laws that protect the judiciary. It's not going to be easy. And I talked about the numbers just a couple of moments ago. But you know what? I believe it's possible. It will take a concerted effort by numerous groups to see this initiative through. Many of the people are on this panel to talk about this topic and are willing to help. It will take coordination, information sharing, gathering of data, and a centralized coalition that will work together to chip away at the long list of states that have yet to enact this crucial type of legislation. I'm in no way minimizing the amount of work that will be required to see this next phase of our journey through. It's going to be a massive endeavor, no doubt about it. However, together, all things are possible. As I reflect on all that has happened since that dreadful Sunday in July of 2020, I have seen what the human spirit can do when it is united under a common good. In the days and weeks following our son's murder, Mark and I received countless cards, letters, gifts from people all throughout the country and even beyond. We saw members of Congress that don't agree about much, they don't, but they agreed on one thing recently. They agreed that something needed to be done to protect our judiciary. We were met with numerous challenges along the way as we tried to get this federal law enacted. But no matter the obstacle, we kept moving forward by confronting the challenges and working together to overcome those challenges. And all throughout our journey, there have been so many forces that kept us upright and helped us along the way at critical points, just so many critical players. Mark and I won't give up pushing for change, despite the enormity of the challenge. We can't give up. We can't sit back. And we can't forget the sacrifice that our son made, not only to save our lives, but to save the lives of so many other judges. Daniel's bravery, his courage, and his love for life has made our decision and our mission pretty clear. Prior to Daniel's murder, Daniel gave our life purpose. Now, post his murder, he's still a guiding light, but this time he's a light that's shining on other people. He's shining on other judicial officers. Together, we can ensure that Daniel's death will never be in vain. And as long as there's hope, we can advocate for change. As long as we stay united, we will have the strength to confront the many challenges that face us. And because Mark and I are faithful people, we know that with God by our side, anything's possible. As I end my remarks this afternoon, I just want to tell you about something that happened right after, well, a couple months after Daniel's murder. In April of 2021, we were invited by Danny's College. It's the Catholic University of America. And they invited us to a plaque unveiling where they have a plaque devoted to Danny outside the steps of their law school, the Columbus Law School of Law. And I want to read the plaque to you. The plaque reads, "Greater love hath no man than this, that a man lay down his life." John 15:13. May we always remember the judges who laid down their lives. May we never forget our loved ones who offered their lives as an act of love. And may we work together to honor their legacies and to protect this country that we all love so much. Thank you for your time. God bless you all.
Thank you. Thank you, Josh Salas. And thank you on behalf of the 30,000 judges and their families across the nation that every day go about following the rule of law and upholding democracy and providing a fair forum for the resolution of disputes. It's a hard job, and we are proud to have you here at the Hughes Center today and be the keynote speaker for this extraordinary event. The next segment of the presentation includes various speakers. We will begin with a presentation by Robin Morante. She is the Chief of Court and Judicial Security for the Administrative Office of the Courts in the State of New Jersey Judiciary, along with Robert P. Archer, who is an attorney with the AOC and at the Advisory Committee on Extrajudicial Activities. And he is the coordinator of the implementation of Daniel's Law on behalf of the court system with the Department of Community Affairs. At this point, I'd like to invite Robin and Robert to come online and begin their presentations. They have a PowerPoint. I would note that the extensive bios of all the speakers is available to all of you. But we want to make sure that all of them have plenty of time to make their presentations. And at this point, we're going to begin with the first segment of our panelists. Go ahead, Robin and Robert. Thank you.
Thank you. My name is Rob Arter. I'm counsel to the New Jersey Supreme Court's Advisory Committee on Extrajudicial Activities. My role is to provide ethics advice to judges. I also advise the Administrative Director's Office in a variety of areas, and that's sort of started branching out into the intersection of ethics as well as information security. Now I'm going to share my screen, and hopefully that will work. Hopefully you can see my screen now as well. And I'm just going to start talking about the presentation. And if, for some reason, if there's any technical issues, I'm sure Judge Mendez can jump in and let me know. I'm going to try to focus on certain themes of communication awareness and personal responsibility. I'm going to try to speak regarding the issues of implementation of New Jersey's version of Daniel's Law and speak from the perspective primarily of the judiciary itself. So as I said, I'm going to try to focus on themes of communication awareness and personal responsibility, but I also want to additionally emphasize given that we only have a short time, I'm going to speak very broadly about New Jersey's Daniels Law, but I'm going to home in on, certain points and certain details that I think really matter, because I think, as Judge Salas said, that, there are more than 40 states that they have to start considering whether to implement laws like this. And I think the details really sort of show you where the issues lie, and sort of they sort of illustrate some of the things that you have to think about when dealing with laws like this. So I'm just going to start with, what is New Jersey's Daniels Law? It was enacted in November of 2020, which is just a few months after the events that Judge Salas just described for all of us. In general, it protects from disclosure certain kinds of information regarding current and former, not just judges, but also law enforcement and prosecutors. Interestingly, it amended some laws that were already in place, but it also created some new statutes as well. And importantly, and this is sort of a focus that I'm going to try to come around to, hopefully in the end, and talk a little bit more about, it's that Daniels Law itself has been amended now several times to both change certain things about the law and to introduce other new things. Now, in general, what does New Jersey's Daniels Law do? First, it amends New Jersey's Open Public Records Act, what we call OPRA, to exclude from disclosure or require redaction of, home addresses and other information from public records. And it also provides a definition of what the law calls a judicial officer. I'll say a little bit more about that later. It prohibits state or local government agencies from publishing the home addresses of certain protected individuals. The current version of Daniels Law, the version that we have now, created what's called the Office of Information Privacy in the Department of Community Affairs, and also directed them to create what we're going to call their online portal. It makes it a crime to post the home address or unpublished home phone number of certain protected individuals with, the certain intent requirements as well. Now, and there are also other provisions in the law that deal with information posted by persons, businesses, and associations. Now, one important thing that I'd really like to focus on in the fact that the current version of Daniels Law does, after getting OIP approval, prohibit government agencies from publishing home addresses. Now, this is something that Judge Salas had just spoken about, which is that sometimes judges will seek to have their information removed from public websites using Delete Me or other services like that. But if you don't really deal with the fact that, where this information is sort of escaping the ecosystem and getting out into the public, it's often the website of government agencies, then you really don't really sever that tie, the first instance where this information gets into the wild, because those public websites, well, not only can public users use those websites to get information, but often data brokers will either scrape those websites or search those websites to pull information. So even if you go and pay a commercial service like Delete Me to remove your information, if you don't have a provision like this that'll prevent it from just being republished, that information can go right back out into the public, or what you might call the ecosystem. Now, who is covered by Daniels Law in New Jersey? The law provides a definition. It says active, formerly active or retired judicial officers, law enforcement officers, prosecutors, as well as their immediate family members who are residing in their same household. Now, Daniels Law also defines what's called an authorized person. These are people who are authorized to act on behalf of a covered person to seek protections through the online portal of the OIP. And for federal judges, that may be the United States Marshal Service. If a covered person becomes incapacitated medically or psychologically, then someone can act on their behalf, like a trustee, state executor, or someone with a power of attorney, or the paralegal guardian, let's say a minor or family member of a covered person who wants to seek coverage. It's important to keep in mind that these are very different constituencies. You might want to compare the language here to the federal Daniel and/or Judicial Security and Privacy Act and see how they are the same and how they differ. But it's also important to really drill down on what we mean by, in this context, judicial officers, because that's the focus today. Now, under this law, it describes a judicial officer as first and foremost a active, formerly active, or retired federal, state, county, or municipal judge. In New Jersey, it also would cover other courts of limited jurisdiction, like tax court judges. But interestingly, also, this term in New Jersey is expansive enough to cover administrative law judges, workers' comp judges, judges who are technically serving in the executive branch. And that's one of the details that I really wanted to call out to folks' attention, is that because, I'm here to represent the judiciary's perspective, the term judge is sort of elastic enough to cover folks in other sort of branches and areas that, I really am not in a position to represent or to push forward. And also you have to keep in mind that the term judicial officer, well, it's not really a term we normally use. It is expansive. And in other jurisdictions, as I think Judge Salas said, that there may be 40 other states or jurisdictions that have to consider laws like that. Well, when they include terms like this, they have to consider, well, do they also have to include things like magistrates, justices of the peace, other definitions or other terms to really make sure that the law that they're enacting covers the people that they have to represent. Now, finally, one thing that I hope I can say to try to tie a lot of this together is something that wasn't actually part of the original Daniels Law. One of the most recent amendments to New Jersey's Daniels Law created what's called the Office of Information Privacy within the Department of Community Affairs. And it also, and this is one of the important things, it actually appropriated money to create the OIP and its online portal. Obviously, I think a lot of people understand that if these initiatives aren't funded, then it can be really hard to get them implemented, because a lot of times you create these laws and you want to actually do something about them, but there may not be a real budget to do it. Also, you have to keep in mind that maybe this is one of New Jersey's particular challenges, with 21 counties, 565 municipalities, and many agencies. Prior to the creation of the OIP, there was a lot of confusion among the different entities. Would you end up with literally hundreds of different kinds of processes? Let's say a judge who lived in one municipality wanted to seek removal of their information. Would they have to do that using one form for their town, another form for their county, and another form for the state agencies? So really, this initiative of creating a sort of one-stop shop was very useful. But also, it's very useful because it gives us within the judiciary one entity to interact with in order to try to achieve these goals. So that actually we have someone that we can work with, or real partners, to assist in removing this information. It really is, important to keep open lines of communication, but also it's important to remember, as I said previously, New Jersey's version of the law doesn't just cover judges. It covers, retired judges. It also covers law enforcement, prosecutors, and also retired and former law enforcement and prosecutors. And from the perspective of someone within the judiciary, someone who's trying to help judges implement these things, it's important to keep in mind that in New Jersey, the largest constituency for people under Daniels Law really are the law enforcement officers. There are approximately 38,000 current law enforcement officers in New Jersey. Add on top of that, former and retired. If you don't really have a single person or a single point person and a good communication with the entity that's overseeing it, the interests of the much smaller number of judges can get lost in the wash a little bit. Also, it's important to be able to talk to these entities and make sure they understand the importance of maintaining independence and impartiality. That's an issue for those within the judicial branch that may not be such an issue for, let's say, law enforcement officers, because you don't want to have a system created or a system within, let's say, the OIP portal where it sort of clumps together the interests of entities that really are supposed to be constitutionally independent. Also, one of the other details that I really want to hopefully hammer home to really help people to understand the New Jersey experience is that there may be differences in current versus the interests of former judges versus the difference of retired judges, because in New Jersey, those categories really are not the same things. And also for those who are implementing laws like this, an issue to remember, and this is why the online portal is so useful, is that especially older judges, retired judges may not be technically savvy and may need the kind of assistance that you can provide, as well as what the online portal and the folks at the OIP are able to provide. Now, I do also want to talk a little bit about my normal area, which is my normal area is extrajudicial activities and security. I try to emphasize for judges that while Daniel's Law is extremely useful, and there's a great deal of importance in making sure that judges are careful about the information that's available on government websites. You should just be aware of the risks associated with your activities off the bench. Make sure you're talking to your judicial security unit in office. Be aware of the information that's being released on social media, because while you may be able to prevent information from being promoted on, like, say, a government website, but you can undermine that immediately by posting an invitation for a party or a photo of your home or a photo of your family. And also maybe a particular issue that I think Judge Salas touched on and others have touched on, it's that in New Jersey, for example, some folks may wish to purchase a little Great Seal of New Jersey for their license plates. Well, that's something that can sort of gather attention to yourself that maybe you didn't need to put on yourself, and work against the interest of security. Now, with that said, I'm going to try to step back and make sure we reserve some time for my partner, Robin, to speak. And hopefully Robin's available.
Yes, I'm here. So first, I just want to say thank you very much to Judge Salas for acknowledging New Jersey as a leader in this area. And, before I begin, and Rob, if you would just advance the slide for us, I would just like to mention the foresight that Chief Justice Rabner and the Administrative Director, Judge Grant, had when they created a standalone court and judicial security unit in 2014 to address these emerging threats facing the judicial branch in New Jersey. And as you can see by the graph on the screen, their assessment of the changing threat climate was correct, spot on, and it continues to intensify over time. Physical security component is, of course, intertwined with Daniel's Law, and a consistent message to all judges statewide from court and judicial security has been and continues to be that anonymity is your best friend. And you do have, as Rob and Judge Salas alluded to, some control over that yourself, vis-a-vis your social media platforms and what have you. And while no security is perfect, some security is always better than none, right? So the statistics that you see on the screen are culled from the New Jersey Incident Reporting System, or JIRS, which I'll discuss a little bit in more detail in a moment. But these statistics are statewide. They represent reports on judge threats. Please note, however, that these numbers are more indicative of subjects that threaten judges rather than the number of judges threatened. Because once a threat or an inappropriate communication is made by a subject, we tend to add additional victims and acts to an existing report for the calendar year. The number of judges who receive threats statewide is actually much higher than what the graph on the screen suggests. So I just want that to be known to the audience. There's also historically an underreporting in the municipal arena statewide, which we continue to work on improving. And despite that, as you can see, the projected number of reports continues to trend upward. So statistically, we see increases in threats during certain times of year. We also, when there's increases in social strife due to perhaps a number of factors, inclusive but not limited to election cycles, related to political discord, times of socioeconomic challenges, and what have you. So, Rob, if you could advance, please. So in New Jersey, we've identified a number of challenges, statewide, and we continue to try to address these challenges proactively. And I think, I've chosen these to kind of quickly go over because I think that they're probably the most universal to the audience. So, challenges with regard to court and judicial security continue to be insufficient communication and info sharing, right? And even getting the info to have. So the JIRS reporting system, again, has been invaluable and is probably the largest source of proactive intelligence that the state of New Jersey has. And I will tell you also of particular challenge is the lack of security specific training and funding for that training for our law enforcement partners. Like when I went to the police academy, I'm going to tell you, nobody pulled me aside and said, hey, let me show you how to run a magnetometer, or hey, let me show you what a protection detail should look like, or how do you do a risk assessment, and how do you investigate crimes when the victim is a high profile person like a judge who is in need of some added protections from an anonymity standpoint. How do you do that? So those are challenges that we have to continue to address. And also, as you could see from the slide before, and there is a great increase over the course of years with regard to threats against our judiciary, that drives demand. It drives demand for advocacy, it drives demand for protection, and it drives demand for our criminal investigations. And obviously we want to create an environment of deterrence. So prosecution is really, really critical. And when you have a decrease in number of law enforcement officers overall, for a myriad of reasons, that creates a challenge that again has to be addressed over and over and over again. And just a lack of overall security personnel to do the work that we need done. And additionally, I would be remiss if I didn't mention that during the course of COVID, we did see, when New Jersey courts were working virtually, there's a greater level of sophistication in threats that occur. There's a trend where I think that when somebody feels like the judge is in their pocket on their phone, there's a weird level of intimacy that I think was created. And so people started acting and behaving in ways that they wouldn't ordinarily. And everybody is really tough behind the keyboard, less so in person. So those types of things we started to see a lot more. So how in New Jersey have we attempted to address these challenges throughout? Well, Rob, if you would advance. So what we did, obviously, is we created the Judiciary Incident Reporting System. There's an online version. So the old version, it used to come in, paper reports on fax, and it would take weeks for us to get them. So, but in 2017, we created an online repository. And these reports are delivered to critical internal judiciary partners instantaneously, and it enables us to quickly triage and engage our external partners. And Court and Judicial Security also mans a statewide judge threat hotline 24/7, so judges have access to advocacy services whenever they need them. So I think that those things are critical. And the JIRS system, not only is it the largest source of proactive intelligence, because what we see is, it doesn't only house threats against judges, it houses information on workplace violence, it houses information on regular security incidents. And I think it's reasonable, and most people that are involved in the court system would agree that perhaps the threat against the judge is not the first act that a subject engages in. The subject sometimes shows up at that service window and creates a problem. And now we have a report that gives us a warning that says, okay, this person created a disturbance, or this person made it difficult for the court to function. So this is somebody that we might have to watch going forward. And that's critical in our proactive assessment and being able to do that. So JIRS really did that for us. And like I said, we went virtual in 2017, and that is how we're able to get the statistics that we do have. Additionally, what New Jersey did is in 2015, the JSMART program was launched, and JSMART stands for the Judiciary Security Management Response Team. It was created by Captain Rick Sema, retired from Somerset County Sheriff, Paul Safer, retired from the United States Marshal Service, and myself. And the three of us partnered, and I will say retired Sheriff Frank Provenzano from Somerset County and United States Marshal Juan Matos, along, of course, with Director Grant, were critical in allowing us to come up with this creative solution. And basically what the JSMART program does is, it creates a platform where we can educate those officers. It is the main source of education. It is the main intelligence sharing and coordination when it comes to threats and crimes against our judges and our system. And also, JSmart does get involved in proposing legislation that furthers our mission. Our first success story in that area came in December 2021 when the governor signed our proposed JSmart bill making harassment against judges a fourth-degree crime in New Jersey. It's indictable, so we can gain some control in a pretrial setting over those types of offenders. And it also allows for the application of a protective order or a restraining type order where judges can have those kinds of restraints put into place. And those things are critical because we do need to talk about how do we continue to create an environment of deterrence to keep our judges safe, because a scared judge is not an effective judge. And it is an attack not only on that judge, but on the system itself. So thank you.
Thank you very much, Ms. Moranti and Mr. Archer, and your email information for both of you is there in case any of the individuals in the audience wants to reach out. As you could probably see, I have two pins, the Hispanic Bar Association pin and the Stockton University pin on today. This is a CLE program sponsored by the Hispanic Bar Association, and CLE credits will be awarded for the individuals that complete an affirmation form that will be sent out to all the individuals, all the lawyers that have registered for the event. And as part of that process, I will give out two codes. I'm about to give out the first code, which is 412-412. It's code number 1, so for inclusion on the affirmation form. Next, we have a speaker who comes from an outstanding national organization called the National Center for State Courts, an institution that provides great leadership at the national level for all the state court systems. And the next speaker is Nathan W. Hall. He's with the National Center for State Courts. He will talk about national trends and challenges that he has observed in his work among the many states around the country. So, Mr. Hall, welcome.
Thank you. Good afternoon, and thank you, Judge Menden. Very excited to be here. I have to say this is a huge issue for the National Center for State Courts. Court security has been an issue for us for many, many years. We work on national issues. We try to track legislation, and I'll try to provide a couple of pieces of information on that. We're advocates for state courts all around the country. We also work in the area of technical assistance and consulting for state courts, conducting assessments for security, among many practice disciplines. So I'd like to share some tidbits of information from the national perspective, and also share some kind of key takeaways that we see when we do local court security assessments that anybody in the audience, whether judges or court managers, administrators, might have an interest in. So first of all, what is NCSC seen from a national perspective in terms of the legislation and protecting judges' personal information? And so, of course, you've heard from the folks here in New Jersey, the excellent things they're doing in their program. And I'd like to point out that there are actually a lot of different good pieces of work being done in states all around the country in terms of making this an issue. And in fact, it's an area that our knowledge and information services is explicitly tracking, is personal protected information and legislation. Our Dr. Bill Raftery he's currently tracking about 35 different bills across 17 states that are active and are pending this year. And I think there's even more that we'll be seeing filed and pending in the coming weeks and months. And so some of the takeaways, and I'll share with you where you can find some of that information to dig into details on any individual states, but taken as a whole, the legislation appears to have a couple of basic thrusts. And the first thrust of legislation in some states include both or one of them, but the first one is the requirement that government entities remove addresses or personal identifiable identifiable information of judges or their families and their searches. And then the second major thrust is about allowing either civil and or criminal proceedings against third parties, vendors, or individuals that post information online. And in some cases, that includes data brokerage companies. And also worth noting, as in New Jersey, a big kind of component is that several of these legislative initiatives and bills go beyond protecting information about judges and their families and include other judicial staff in addition to law enforcement, prosecutors, and other public officials, as I think Robert had mentioned about New Jersey. So there's that piece of legislation. Another piece of security that Robin was talking about is threat and incident reporting and threat management. And so often the National Center gets requests about what do we know about court security incidents. And I'll answer that question in a second, but we do know, obviously, and a lot of people have mentioned that the U.S. Marshals Service tracks threats and incidents, and a few states, and I say a few on purpose, like New Jersey, actually have a threat and incident management program, and we'll get into those details more. There's more than a few, but the robustness is quite diverse. But for the stats we do know, obviously, the U.S. Marshals Service annual report, the last one I had was in September 21 ending, was about 4,500 threats and inappropriate communications against judges and other protected persons, which is nearly double what they saw a few years before that, I think 2016. So those numbers are certainly eye-opening. But what are we seeing on state courts? Those numbers don't capture what our judicial officers that are working in the state court system are seeing. And in fact, the state courts are called the workhorses of the judiciary. There's approximately 30,000 state court judges in our country. There's about 1,700 federal judges. In terms of the volume of cases that come through, there's about 95% of all cases heard in the country, about 100 million are filed in state courts. So, given that, it's not surprising to see that we receive requests from judges and court administrators and others in the media about, okay, what are the threats occurring to state court judges? It's a natural question. And I'll get back to the main question is, what are the numbers in CSC? And the answer is, gosh, there's no national threat database for judges. Why is that? There's several reasons. So first of all, you mentioned New Jersey has a really good system in place. And there are systems in place in other states, and either the survey NCSC did in 2020 and about half of state court systems that we heard back from do have some sort of threat and incident reporting system. Of course, some of them are very modest in scope and their capabilities. And then kind of a tag along to that, a second reason is that, about half the states we surveyed have even a standardized threat and incident reporting form, let alone a centralized reporting and repository system. And the third reason is that when you look at this issue nationwide, there's not even nationally or universally agreed upon definitions of what a court security threat or a court security incident even is. So, for example, would it be reported if a threat and incident reported outside of the courthouse grounds? Well, in some states, it wouldn't be, so such as a judge's home. Another thing I'd like to point out for the audience is that, this is a renewed call, but it is not a new call. In fact, there has been calls for a national state court security incident reporting system for many, many years. There was a national summit on court security that was convened in 2006 by NCSC. That was following the infamous Atlanta courthouse shooting, which claimed the life of the judge and two others. And that summit called for a national threat and incident reporting system. So kind of shifting gears. Okay, so everything is local, though. There is a lot of things that can be done locally. But when we do a security assessments around the country, we often find that there's not even local reporting of threats and incidents, and not a clear understanding of who collects it and where the repository resides, or even local law enforcement having confusion over when a threat is reported and they conduct an investigation, and maybe that should be public, maybe that's actually sensitive law enforcement investigative information. So kind of identifying what a threat and incident reporting system is, what it can be used for, and what types of information it has is really not out there in the world in state courts. So hopefully that information to you all, or I should say the lack of information, rings with you and rings with judges and court administrators nationwide. But I'd also like to like to share my experience on some of the things NCSC has learned for local courts when we've done assessments of courthouse security. I'd like to point out we've done probably well over 300 assessments since we've been doing this over the last many years, especially since the 2005 incident I mentioned. And so what do we know now? We know now, first of all, that the threat landscape is rapidly evolving. It's evolving to include major social political challenges, which we can all see. We were rapidly increasing in cybersecurity threats and incidents. We're seeing huge impacts of court systems from major natural disasters, and we're seeing an increase to personal threats to judges and all public servants. So with this in mind, one of the biggest deficiencies we see and that we're going to be seeing is that there's not always a holistic strategy that kind of puts these under an umbrella. And the tendency is to work in silos. So in our recommendations, we like to look at a more holistic security planning strategy, which means having a comprehensive strategic plan and including experts from all aspects of your court organization so that we can bring together this different pieces of threat mitigation. What do we want to see in terms of that? Obviously, avoid working in silos, right? Does your court security director have a direct line of communication with your court administrators, providing judges special programs, your IT directors, so on and so forth? So looking at how do we address court security, building security in line with emergency preparedness and continuity, in line with cybersecurity and planning, those are all interrelational. And then the impacts of personal safety issues kind of cross the whole gamut of those. So we talk about the benefits of that holistic threat management strategy that can be really beneficial. We also like to talk about how the enhancing collaboration and coordination between not just court leaders, but also justice partners and stakeholders. And then another key point of this kind of line of thinking is that making sure that coordination of information and that we are providing greater resource sharing between stakeholders. Because at the end of the day, we think that this will give courts increased capacity and expertise to present, mitigate, and respond to this evolving threat landscape that we're seeing. Another key point I'd like to point out, if I have time, is that we often see that when court security is brought into play at a local courthouse, there's a lack of a comprehensive security plan. So security is dependent on the active involvement and attention of tons of stakeholders. Security does not happen in a vacuum. And I like to think of maybe four major pillars that it's dependent on, right? You have your security operations and your protocols and your administrative elements of it, but you also have architectural elements. You have the security technology and equipment that drives that. And then you also have your individual involvement in your own security awareness of staff and the training for staff and security personnel. So as a comprehensive way, we see that these are not always in place. For example, we've assessed brand new state-of-the-art courthouses where our conclusion is that the security is essentially significantly deficient because you have a breakdown in one of the areas of overplay. So, looking at your courts in a comprehensive manner when it comes to court security is really important. I'd like to plug a resource for that, and that's the Steps to Best Practices, which the National Center is currently on its 4th edition of. It was first written in 2010. The last edition, 4th, was in 2022. But this covers the full gamut of all the comprehensive aspects of security. And it's really important because regardless of whether you have a single courtroom in a 100-year-old building, or if you have a bunch of courtrooms in a large high-rise metropolitan brand new courthouses, it gives you a framework and a common way to work on things that you can build a path forward in a kind of steps and phases process that you can build on over time as resources become available. A third takeaway, I'd like to share the number one fundamental element that we do have in our best practices that we don't often see in place. I shouldn't say don't often, but often don't see, surprisingly, is a effective governance structure that's in place. And that's in many places is the piece that holds the glue together for all these parts and pieces and takes really strong leadership. In most places, in many places, it's called the Court Security Committee. In fact, there's many states that require that local courts have this in place. But despite these requirements, we find that often they may be in place, they may be informalized, they may not be working effectively. So that's the number one place to start, because if your court security is not working effectively, you're not going to get along the path to doing any better incident reporting or threat mitigation or the tangible things about improving your overall posture. And so what does it look like? With all the stakeholders involved, it's generally a multi-headed monster. And so managing that and leading that in an effective way, making sure that your chief judge or presiding judge, that sheriff, those people that are in your county board or legislative local entity or facilities, that those major decision makers are there making the decisions. Because we often see that people get frustrated that they don't have real decision makers and there's no real action taken because the work is real. And in some cases can cost significant resources. On the other hand, you often see people that say, gosh, there's too many people. So finding that balance is important. And then before I go, I'd like to kind of look at a fourth area of improvement that we often look at in our assessments. And that's kind of making sure you have the right policies and procedures and protocols in place. And this would include how security is performed and whose roles and responsibilities we're doing what. And really, this has to be a clear understanding in relation to emergency events. And we have a couple of great speakers talking about how judges and staff deal with threats. But on a courthouse planning basis, there needs to be some framework for staff to understand who's in charge when things go wrong. And there are a lot of things can go wrong. And honestly, I think most people would be surprised to see how many courts are caught off guard when an incident happens and when there's not a clear incident command structure or clear response protocols in place. So the last question I will leave you with is, when your court experiences an emergency situation, which most at some point will, frankly, will your judges and staff know what to do? So with that, I'll leave it back to you, Judge Mendez. Thank you.
Thank you very much. Thank you very much. We have two additional presenters. And before I go to the next one, I just want to acknowledge the help that the Hughes Center has received from many organizations to promote these events, this event, including the New Jersey State Bar Association, the National Association of Presiding Judges and Court Executive Officers, NAPCO, and the local prosecutors and the State Prosecutors Association, sheriff departments, and the Sheriff Association as well. So thank you to everyone that has promoted this forum. Next, we have John Muffler. John is formerly with the U.S. Marshal Service, National Center for Judicial Security. The more I researched this issue and read about it and read many of his articles, he's written 30 of them on the issue of judicial security. He's worked with many organizations, including the American Bar Association, the National Judicial College, and of course, the National Center for State Courts. So he is perhaps the leading national expert on judicial security. I'd like to introduce you to Mr. John Muffler.
Thanks, Your Honor. Appreciate it. I just want to be cognizant of the time. So there's a couple things I want to cover. And primarily, I'm going to start off talking about a couple of the state courts who have, or states that have passed legislation. But I really kind of want to get into the why they pursue an attack, who attacks, and where they attack. And that couple minutes that I have here. So we talked about numerous states. Obviously, New Jersey is front and center with new updated legislation. But a couple of the states that were mentioned earlier, or at least on that list of the couple dozen, California, Illinois, and Texas, and New Jersey only passed legislation to protect after a judicial officer was either killed or injured at home. So it's important that those states that are either enhancing or not looking at it right now need to look at what New Jersey is doing, look at what California did back in the early 2000s. That legislation was passed because a judge and his wife were murdered at home. And in Texas, we saw the Judge Kucera Act passed after her assassination attempt at home in front of her family. And there are a laundry list of judges' names I could mention at the state level and federal level that were attacked at home with their wives and their loved ones also injured. But again, that's for another time. But so why are they doing this, right? Why are these individuals, committing such an act of violence towards a member of the judicial branch? It really comes down to behavior typologies. And I want to talk a little bit about commonalities of judicial pursuers, because they're a little different than, say, someone who pursues a celebrity or a different type of public figure, say like the president or a governor, et cetera, right? So with judges, we see that the grievance is built right in, right? There's this pathway to violence, term we use in threat assessment. It begins with a pathway. It begins with a grievance. Why have I been wronged? And it could be a real wrong. It could be a perceived wrong. And as a Philly mobster who I once protected in the program years ago said to me, a fair exchange ain't no robbery. So what they've experienced with that decision may make a difference on what they do in pursuit of righting a perceived wrong. So it begins with that grievance, and that's built in with the judicial pursuer. And then there's this ideation part where they're thinking about it. Do I want to, right this wrong? And then they start getting into the research and the planning. And in the research and the planning, if you think about this and think about what Judge Salas just said, it's the PII. They're looking for PII. And it's easy to find that information in the media age, here in the social media age. So at some point, that individual will go out from behind their computer after finding out that information and begin to mobilize to action. And they're being overt, right? And so then they're going to probe and look to breach, right? And this is research I'm identifying by Ted Calhoun. And after that is the attack. Judge Salas said something very profound to me. And if you follow this type of behavior, whether it's judicial or celebrity or even school shooters, there's some commonality. So some of the warning behavior typologies that jumped out of me with the murder of Daniel and the pursuit of Judge Salas, that was the number one target, was her attacker, Daniel's murderer, was fixated. It's the same way as other judicial pursuers are. They're fixated on righting that wrong. And so they do these behaviors I already mentioned. And so they become exposed at some point. It's very interesting, the common features between Judge Salas's pursuer and Judge Kosurik's pursuer, right? Judge Kosurik, an unfortunate side story to this is there was leakage and there was a directly communicated threat, which is very rare for that to then be carried out with the Kosurik attack, right? But law enforcement ignored it. They dismissed it. And then a week later, she was shot in front of her family. But her pursuer was jogging by her house, right? He was looking for her. He knew her routines, just like Judge Salas. So did Bart Ross when he was pursuing Judge Lefkow. So they're doing these things. They were showing these behaviors in pursuit of the end result, which is to find the judge, the person who did wrong in their eyes, right? And so, but in the Kosurik case, her attacker jogged by the neighborhood, drove by the neighborhood numerous times. We know this from evidence in the trial, jogged through the neighborhood. But because she didn't know that there was a directly communicated threat, she didn't understand what she was seeing as she's putting out Halloween decorations. She sees somebody jog by her neighborhood in street clothes, which is unusual. But she never knew about the threat. She was never told that someone was going to try and kill her, believe that or not, right? So her intuition was never charged, right? She never knew, like, when that hair on the back of her neck stood up, that was something. And I find it very interesting that Judge Salas and her her son's murderer lock eyes. That's profound to me. So they have that behavior. They're doing these things in furtherance of this attack. So it can be known. So talking about intuition is key. Gavin de Becker talks about this in his book, Gift of Fear. There's a great, you can go on giftofear.com as a shameless plug, but it's free. It's a master class in intuition and situational awareness. But he talks about that. And Judge Salas and I, as well as everybody on this call today, as far as the panel goes, she said something to me that was very striking again. She said, if you feel something, do something. We know the campaign, see something, say something, and that works. That is working well within the school and workplace environments when there's behavior that's disconcerting being reported. But before you see it, you might feel it, and that's intuition telling you something's wrong. Intuition has your best interest at heart, and it's going to tell you, be mindful, watch what you're, listen to what you're seeing. And I'll repeat something that Gavin, Gavin de Becker, whom I work for, says quite often about intuition. Think about a gazelle down by the water, lapping out, having a drink, and then here's a crunching of the leaves nearby. That gazelle is not saying, oh, it's probably nothing, right? It's out of here. But we as humans tend to wait to get all the information before we make a decision. But sometimes that is too late, right? The other things about the commonalities with the judicial pursuers that we know is they live in the community they serve, right? So they are approachable. They are in proximity. They are not in, say, a state house like in Trenton or in DC, but they live in the community they serve. So they become more approachable. the court experience for the pursuer is the triggering device to follow along that pathway. And a couple things I want to give, if there's any time left, obviously Chris has got to speak, but there's research out there. It is so minimal. And one of the things that I did with the National Judicial College recently, and it's not released information, is looking at behaviors of those who threaten, those who communicate inappropriately. And is there a difference? And I only went about this with the NJC because for 15, 16 years, I've been on the faculty there, and I'd have one female judge after another female judge saying, is there a difference between those who pursue female judges and male judges? I'm like, there's no research. So we endeavored to do that. And I can just read this off real quickly. But we found, and this is a stratified random sample of 2,000. We had 400 respondents. It was a 50-50 split between male and female. Male judges are more likely than female judges to be taken seriously with a security issue. Female judges, and that's 75%, experience threats and inappropriate communications more than their male counterparts, and that's at 62%. So this information is important because we can help categorize threats and the threatener, and have a more useful way to operationalize our decisions, et cetera. So I'm trying to get that done in a couple minutes, but I know Chris is coming up next, and hope he has some time to speak about his experiences at Utah state courts. Thank you, everybody.
Thank you very much, Mr. Muffler. I just want to announce that there will be a little bit of time at the end for questions and answers from the various panelists. If you wish to do that, use the Q&A button on the bottom of your Zoom account. At this point, we're moving on to, and by the way, at the conclusion of the next presentation, I will be giving out the next CLE code for those who want to get CLE credits. The next speaker is John Palmer. He's the Court Security Director for the state of Utah, formerly with the United States Air Force. In that capacity, he worked security at the White House, brings a tremendous experience and perspective to this issue. And he's going to talk about personal security steps that judges can and others can take to ensure their safety. So with that, may I introduce everyone to Chris Palmer.
Thank you, Judge Mendez. I want to say thank you to Judge Salas for her testimony. A lot of times it's difficult to quantify the mindset of a victim of an attack in the context of moving people towards action. And that takes an incredibly brave retelling of that story. It's difficult sometimes to put into perspective, but I'm also very fortunate to be within a group of actually just humbling experience between John and Nathan, Robert and Robin. Just the last couple of weeks, you guys have to understand that being around this group of people has been very enlightening for me. So my topic, being the last of this, is to talk about what happens next. The mindset that you need to have and that you should instill in those around you once you know somebody's going to try to kill you. Oftentimes we'll lose time with somebody confronting us with how do they figure out where I lived? How do they figure out where my routine is? Why me? Why now? So I want to talk about the mindset issue, and I'm going to quote a book too. Although I pull heavily from what John said, I'm a big fan of Gavin DeBecker. In fact, the books that he puts out, The Gift of Fear and Protecting the Gift, both are almost always mandatory reading for me when I have new judges come on board. But I'm also adding a third book to this, and it's kind of an unusual book, and I'll tell you why. It's called Violence of Mind, Training and Preparation for Extreme Violence. And it's written by an author who does a lot of police training. And what it gives you on is perspective of how the mind of the killer works, how the mind of a person who's obsessed with hurting you works. And once you understand that, it's equating to, for those of you who go through oral arguments, you spend a lot of time thinking like the enemy does in your personal preparation for in this context of being your own advocate for your safety. It starts with those threat assessments. It starts with the first moment you recognize that somebody is going to try to hurt you or potentially could hurt you. And that on-ramp for that is varied. It could be a neighbor telling you, it could be a friend, it could be your judicial assistants, it could be a concerned individual who notifies you of a threat or communication. And as John talked about the gazelle story, human beings, we need a lot of positive affirmation before we make a decision. And bad guys don't really call you and say, you know, because your awareness, because you had a street sense and you made eye contact and you prevented the attack, they don't call you and tell you, hey, you did a good thing. So you don't have that constant reinforcement of making the right decision. So in that context, when you think about how somebody's going to try to hurt you, you need to think like the enemy, just as you would prepare for your opponent's arguments. And it starts with your threat assessment. It starts with being that advocate. So when somebody approaches you and says there's a threat against you, you need to ask questions such as, what are their capabilities? Has a lethality assessment been done? How capable is this person? Do they possess weapons? Do they have a history? If not, are we documenting it? Oftentimes, and especially the struggle that I face is bringing that to a threat intelligence level. For example, when I worked at the White House, it was very easy. If somebody made an online threat to the President of the United States, I would get all kinds of support. But I have a state judge who has inappropriate comment directed at him through social media, and I have to contact a local law enforcement agency, and they say, well, it isn't really a direct threat. And then you have to ask that question of, if it isn't a direct threat, what is it? Could it be an inappropriate communication? Does it need to be documented, and how so? So you have to be that advocate. You have to answer that question. And one of the things that I always do is, if you believe this not to be a direct threat, I'll ask for them to put that assessment in writing. It's keying on to them that they need to document their activities and behaviors. So moving on, you need to develop your plans. Risk mitigation and risk elimination. Our jobs are not without risk. As Judge Salas said, somebody tried to murder her family and her because of the job she did. It's a very troubling concept that somebody hates you just because of something you do. That I'm sure nobody does this for fame and fortune and incredible wealth. They believe in what we do. The practice of law, our judiciary, is what separates our country and makes it so great. So having your response plan, your risk mitigation, elimination, make sure you discuss these plans and often run them by other people. Your plan should be tailored for you. Be aware of any time that somebody gives you a blanket list of things you can do that you can't apply directly to your life. For example, if you live in a rural community, there is only one way to and from the courthouse. If you live in a large metropolitan area, you have multiple ways. So make sure that you explore ways to mitigate that. So if you live in that rural community and there's only one way to and from work, you can find things that your areas of your concern, and you can bolster those things. And the reason why these attacks are so tragic and they occur in the place they do is because it's the same theory of asymmetric warfare, guerrilla warfare, if you will. They're not going to attack at a place where you're the most defended. They're not going to attack you on the bench. They're not going to attack you when you go to the shooting range. They're not going to attack you at the front door of the courthouse. They're going to attack you at a place when they can cause the most fear and they have the advantage. Your home, your car, out with family members. So those are the areas you concentrate on. You come up with those plans and discuss those plans, and then have other people help you develop those plans. It is not just you on your own. You have a wealth of knowledge. Somebody asked in the chat if there's going to be a line, a see something, say something hotline. There could be. You have a wealth of resources, whether it's your court security officials, whether it's other judges, whether it's anybody on this panel, we'll take a call at any time. But you guys have that on there. Ask questions. Ask questions of your security providers. What can you do? The National Center for State Courts, Nathan, has a wonderful website where it's full of tips and things you can look at for your home. Print that checklist off and walk through your house and ask yourself those questions. Are we doing the most we can to make our house a hard target? Is it well lit? Have we talked to our neighbors? Are deliveries coming to our house that are unusual? And as several panelists said, when the hair in the back of your neck stands up, are you willing to make that report? So my fourth point is the threshold for what's unusual, what's weird, what makes you pause for a second, it should be very low. You should call it in. You should not feel guilty about wasting somebody's time. You're not delaying anything. This is very important. John and I both have been out in the field. I would rather take 100 phone calls that turned out to be a lost person in the neighborhood than have you dismiss that danger signal, that gazelle at the edge of the river, one time. Your threshold needs to be low for suspicious items, very low. Don't just wait for something to occur. Deja vu doesn't exist in my world. If you see somebody twice, 3 times through your neighborhood, absolutely, you're going to call the police immediately. And going back to what Judge Salas said, she watched that killer. He was in her neighborhood. He was staking out her house. She locked eyes with him, which is an absolutely chilling thing to think about. But after that, she learned something. She learned that this guy was looking at her, had tracked her down, and she asked questions of the FBI. He wasn't her only target. She was one of many. Think like the opponent. It's a horrible thing to think about. I'm troubled that we have to discuss it, but you have to think what the bad guy's going to do to you. You have to constantly be reminding people around you what your plan's going to be, developing a duress plan. Do you have a word that you could say to people around you to let you know you're in distress? Does your family know? My family and I have used the same duress word for 20 years now, and it's asparagus. So once you have these things in place, you're not going to lose a step. When that guy comes and knocks on your front door, you're already going to have a plan in place. What are you going to do? How are you going to communicate that plan? And you're going to survive. The will to survive. The fact that most of these killers rarely plan to survive their encounter. And in fact, their mind, when they start their killing spree, whether it's a mass killing spree at a school or a target attack against an individual, they have built up in their mind that you're not going to attack back. You're not going to fight back. You're not going to resist in any way, shape, or form. You have to change that in their minds. You have to make yourself a hard target. Thank you very much for the opportunity to speak today with you. Thank you for the opportunity for our panel to be able to talk about this and bring this in mind. I was struck that 500 people or more are here and they're all engaged in court security. Go out and ignite the same fire amongst your staff, your judiciary, your local bar, your inns of courts, all of that. So thank you, Judge Mendez. Thank you, Judge Salas.
Thank you, John. And one of the questions, and again, the question and answer chat is available. We're going to be answering questions over the next 15 minutes or so. One of the questions is, can you repeat the name of the book that you just mentioned in your remarks?
Sure. Yeah, it's called Violence of Mind, Training and Preparation for Extreme Violence. And it's by a author named Varg Freeborn, V-A-R-G F-R-E-E-B-O-R-N.
Thank you very much. The next question, one of the attendees indicated, in the spirit of see something, say something, is there a hotline number for judicial security concerns that is available, whether at the state level or nationally? Is anyone aware of a hotline? Should there be one?
Judge Mendez, Court and Judicial Security in New Jersey does have a threat hotline that is a 24/7 hotline that is manned by this office. We also have an infrastructure hotline if there's any problems with security tools and any ancillary sites of ours, and that is also a 24/7 hotline. So yes, New Jersey does employ 2.
Is that a 800 number that is available?
No, we're not that sophisticated. They're actually judiciary VoIP lines. Because we do forward them to, I man them myself as well as a number of my executive staff.
Should there be one? I raised that question to some of the panelists. Well, I'm going to answer. I think there should be one. Absolutely, it should be an available.
Well, yeah, I think each institution, each jurisdiction.
We're having some technical connections with you.
You know, something beyond.
We could not. I think we lost you for a moment there, John.
Oh, you missed it. It was like the most profound thing I ever said. Well, my point was, Yeah, each jurisdiction should have some number. I mean, other than a 911 call to
Mhm.
make. I think it's like a no-brainer to me.
I mean, I think that federal judges are told and you know, depending on the districts, the United States Marshal Service does an excellent job in making sure judicial officers know who they're paired with and the numbers. And especially when we travel, they always have an introduction by a U.S. Marshal, a deputy U.S. Marshal in charge. But I think this goes to the issue of sort of thinking about how we now can centralize security at a state level and at a federal level. And a lot of discussion needs to be had. But I feel like based on what I've heard and the little research that now I'm beginning to do as it relates to state court judges, we need to see, you know, how we can combine our efforts and not duplicate the work that's going to be done. And that's going to take really, as I said before, you know, communication, collaboration, and cooperation. And those things that all the people on this call and on this panel have information. And I do think the dialogue needs to be had. What can we do to centralize these inappropriate communications towards state, local, federal judges? And how can we at least answer questions at a moment's notice, if necessary, for those judicial officers that feel something and want to say something?
I can just add one thing, and I 100% agree. And this is, again, beyond collecting the data. It's the research that can be taken from that data, from the types of threats and the types of threateners, and that information can be operationalized. That can help all the judges in the communities. So that is, it's so important to get that information. It's the next step is get the research out of the information.
Definitely.
question-
I'm
Go
sorry.
ahead. I was
No, I
going
was
to
just
say one.
gonna say what John, piggybacking on what he said. And I think that the JSMART program and the JIRS program do work in conjunction, because there is an acknowledgement in New Jersey that the same actors that we see in the municipal court, they end up in the superior court, they end up in the federal system. And so that is why that JSMART program encompasses federal, state, county, and local partners in conjunction with this office, because there needs to be that striation of sharing that comes, and so that we can be as proactive across the board, across all of those court systems in New Jersey collectively.
The point that Judge Salas made in her remarks is that we do not have a national depository of this information. So something may be happening just across the river in Philadelphia or New York City, and they know about it. And this person now comes to New Jersey, and we don't have that information, and that becomes that's part of the really gap in the system. That hopefully that will be a very important takeaway from this discussion today. Somebody's got to work on creating this, whether it's the National Judicial College or the National Center for State Courts, or the combination of different jurisdictions. There's another question about Daniel's Law and whether or not it extends to family members who may not be members of the household, because that may be a way for the potential perpetrator to access personal information involving the judge. Robert?
Hi, I think the short answer is the New Jersey version of Daniel's Law focuses on those members of the immediate family that are residing in the same household. I don't see that same limitation in the federal version, though Judge Salas may be more of an expert on the federal version than I am. I think it's true. I think that's probably correct, that that's sort of an indirect way. And that's also something that I think some of the other panelists can talk about as to how to talk to family members who may not be, residing in the same household, about trying to make sure that they're not revealing information on social media or in other ways that could, reveal information that's not necessarily directly protected by the version of Daniel's Law that applies to you.
There's another question about vanity license plates. And, I spent 10 years as the assignment judge of Atlantic and Cape County, and I met with every new judge and advised the judge not to get a vanity license plate. And a few months later, most of them got it. And it's a bullseye. Mr. Muffler, you want to comment on that?
Yes. I do. Thank you. How'd you know? Yeah, I have a collection. I do presentations. I have dozens of pictures that I've taken personally that people send to me of a vanity plate that belongs to a judge because it says judge. And I'm assuming it's not your last name because you put other clues together that of the lanyard hanging down from the courthouse, from the mirror. You know, it all adds up, right? So, yeah, I know, like in Texas and maybe other states, I think Texas still allows that. And I always say, it's not a good idea. Everybody has a video camera, not just because you're a judge, but you could be speeding or doing things you shouldn't be doing, perhaps. But yeah, it's just a bad idea. I mean, it's a giveaway of information. This is PII in front of you driving, right? Don't give anything away. Don't put that you went to Stockton, great university, on your windshield, your back of your car. Okay, avoid any advertisement.
By the way,
Judge Mendez, I
go
was
ahead.
going to jump in here, and I was just basically, I think judicial officers all over this country need to take a certain amount of accountability for their own protection. And we heard, all of these great presenters talk about that. But it really, I don't know, one of the things that some people still have yet to do is Google themselves. And if you Google yourself, you're going to be able to see what comes up. And one of the things that for me, I just want my brothers and sisters on the bench to know, which is that there are so many things that we can do to minimize our online footprint. But it takes you talking to your children. It takes you having a conversation. Look, the reality of our situation, it was COVID, and we were getting all these deliveries brought to the house. And prior to, our brutal attack, we had talked to Danny about, if you see a box and you didn't order anything and it's mine, wait till, call me, make sure I ordered something. But we talked about mail bombs. But at that time, during COVID, there were a lot of independent drivers driving for Amazon and other companies, right? So all of a sudden, between Danny ordering Uber Eats and everything else, we just got desensitized to people coming to the door. But the conversations have to be had with your children. You have to have a conversation that says, if you don't know who's ringing the bell, you're not answering it. You have to, and I know that there is a certain level of sort of that I struggle with when we talk about, neuroscience and not wanting to traumatize our children, but we're also talking about not wanting our children to die. So there are tough conversations that need to be had if they haven't already been had, and it's up to the judicial officers to have those conversations.
Thank you. By the way, I'm about to give the second CLE, and hopefully all of you will remain on the call after I give it out. The second CLE code is 424. And again, thank you again to our court sponsor, the Hispanic Bar Association, for doing this. And Judge Salas, the Hughes Center is committed to this issue and will continue to work with you and with other organizations to promote the discussion about this important and advance the important discussion about this important issue that affects democracy. One of the questions was about parking and security, parking security and courthouse security. Perhaps, Mr. Hall, this is an area that you may be most familiar with.
Thank you. Could you read me the question?
Well, the question is, should all courthouses have secure parking?
Yeah. Okay. Yeah, excellent. That I do agree with that principle. I think that it can be tricky because if you have an older courthouse in an urban area, you might have a situation where you're having to traverse a different location even. But so, yes, ideally there should be some secure parking. The best practice is to have it not for the public, but for judicial staff, like under the building directly with a secure entrance. Going beyond that, you probably want to make a secure outdoor parking area. You want to fence it off, and you want to make sure that that fence is opaque. Better yet, maybe a brick fence that goes around it and the access gates. But then even so, we know that there are judges sometimes that have to walk a distance. So then taking an assessment of that path in those areas where they're parked and putting call boxes in with arrest alarms and appropriate lighting and response techniques. So I think it goes back to that sort of progressive thing of doing what we can, because doing nothing is definitely opening yourself up to.
There's a question about social media. Perhaps I'll open it to the entire panel. Any advice in communicating threats to large social media or other private platforms shielded by Section 230? Anybody wanted to comment on that? Should judges be on social media?
I would say, generally speaking, no, but a lot of the, and there's another reason for that, just other than safety and security, there's ethics issues to be considered, because you can end up with ex parte issues. So there's an ethics issue there. But there's judges that run for office across the country. There's 30,000 plus state, local judges. So they have to be on social media to get elected. So, but what do you put on social media and what shouldn't you put on social media? That's the difference. And so, but again, policing that information, being mindful of what you're putting out there, giving away PII. Remember, that information is currency for an attacker. So you gotta be careful of what you're putting out there in the first place.
I also
Thank you.
think that knowing what social media is and is not, right? Theoretically, your Amazon account is social media. You can evaluate products there. You have a profile, your address is there, and you can have wish lists and everything else. So I think sometimes there's not a clear awareness from folks to discern what constitutes and doesn't constitute social media and where people can call your personal information. That's critical.
I have
go
one thing on that. If they are going to engage in presence on social media, they have to be very strict on the controls that they'll do, the information they'll do, put out, pictures to postings to everything that they do could be called and used against them. And then you're weak linking that, and it's usually the people you're associated with, because even if you don't have a very strong social media presence, the people around you can build that by, and that circle gets built in that connections. John.
Real quick, on the social media and the Kosurik case, her attacker found sports boards in front of the house with her son's name on it, and then he found her son's Instagram account, and he was able to follow Judge Kosurik's son, knew they'd be at a football game, and then laid in wait at the house until they got back. So again, it's not just you, it's your loved ones. So being mindful of what you're giving away is important.
Yeah. Do states, Mr. Hall, maybe do states have all states adopted security plans or security policy for their court systems?
It depends on what state. So certainly there are some states that have some model security plans that are developed, and it's in a template fashion. And there are some states where, they don't even know what a security plan is. So I think we need to have a broader discussion too, nationally, not just what incident reporting is, but what is it when we're looking at the world of court security, how we get the commonalities of what even is a security plan. In my mind, the security plan covers all the topics, both operational, facilities, technology, and it's laid out in a clear manner, and includes a self-assessment or a professional assessment of where you're at and steps to get better. And so I do know that depending on if that person wants to reach out to me in email, there might be some examples I might be able to provide.
Thank you. I'm gonna refer to the next question in a moment, but again, I'm going to repeat the codes. 412 was the first code. 424 was the second code. Judge Salas, the next question is about funding and grants and the ability of providing that to states so they can be incentivized to implement systems and maybe even have more dedicated law enforcement on the for safety. Where is that at this point? Is that something in the works?
Well, we are working now, the Federal Judges Association, in collaboration with bankruptcy judges as well as federal magistrate judges, federal bankruptcy judges as well, and their associations. We are working now to try to encourage the subcommittee on appropriations to set aside money for the grant program. Sadly, right now, President Biden's budget request to Congress, which was issued on March 9th, didn't have a separate line appropriation for the grant program. And so when we became aware of that, we are now working again, banding together to try to encourage President Biden along with Congress through the budgetary subcommittees to budget money for the program. We will work. We will not stop until we obviously have a line item, hopefully a line item and budgetary appropriations for the grant program. So the answer to that is we're working on it. The bill was just signed into law on December 23rd, and which is one of the reasons why some of it didn't get, I think, appropriately funded or at least requested in terms of funding by the president because of the timing of when it was signed. But the answer to that is yes. I mean, we're going to work together to not only encourage our sister states to enact similar laws like New Jersey has, but on a parallel track, continue to encourage Congress to really fund the initiatives, especially the state grant program, because as we've all heard right now during the last 2 hours, we need to protect all federal judges, and that includes our state and local judges who are doing their job and are at risk as well. Because they have agreed to serve as judicial officers for their particular state.
Well, it's now 5 o'clock. We've had an extraordinary 2 hours, Judge Salas. Thank you so much. This has turned out to be even better than I even anticipated. And we'll continue the conversation. And I want to extend my thanks to all the panelists and to everyone at Stockton University. I had a little bit to do to putting this together, particularly the Hughes Center. And then there's staff there, John Frungen and Daria and everybody else. And with that, Judge Salas, God bless you and thank you very much. Thank you.
Take care.
Thank you, Judge Mendez, for putting this together and for Stockton for inviting the Hispanic Bar Association. We will continue to have conversations. We remain ready with our sleeves rolled up to help in any way we can and to further the discussion.
Thank you very much, Abby.